judge overseeing the YSL trial says he's not going anywhere. Atlanta rapper Young Thug's attorney tried to remove Judge Glanville from the organized crime trial, accusing the judge of joining the prosecutor's team. Atlanta News First reporter Rico takes us inside the courtroom. Defense attorney Brian Steele filed a motion to have the judge removed from the case. He claims the current judge is biased against his client Jeffrey Williams, a.k.a. rapper Young Thug. The judge, overseeing the rico trial, denied the motion to recuse himself from the case.
I've consumed everything on it, and that doesn't change my ruling at this point in time, respectfully.
The motion, filed by rapper Young Thug's attorney Brian Steele, largely centers around the meeting that occurred earlier this month between the judge, prosecutor, and the key witness. Steele alleging the private meeting was improper and that defense attorneys were not notified about it.
How did you get that information supposedly from my chambers?
Steele's refusal to divulge details about the conversation that occurred during that meeting prompted the judge to hold Steele in contempt and give him jail time.
So I've added this court to the witness list.
While the judge plans to stay on this case, Steele says he plans to ask witness Kenneth Cochran about that private meeting during cross-examination.
And when that day comes, I'm going to ask him about how much pressure, if any, the court put on him. And you're going to be the one instructing the jury. And I just can't imagine how that's fair to Mr. Williams.
And the judge also indicated today that he will likely reschedule that June 25th hearing pertaining to that private meeting.
By the end of the day, papers were filed. Let's get into it. Okay, you guys, I'm giving you an update on the YSL trial. And looks like Demonte Kendrick's lawyers filed a petition for writ of mandamus and stay of proceedings yesterday. So basically, they went over the judge's head and went straight to the Supreme Court. So let's get into what this filing has in it. And I'm sure it's in reference to the recusal of the judge, which he denied the other day. He denied Steele's refusal. Okay, let's see here. Okay, this emergency petition concerns allegations of serious breach of the Georgia Code of Judicial Conduct that violates petitioner's state and federal constitutional rights. This petition relates to conduct of Chief Judge Glanville and not to any rulings or order of the judge. And it's going down here. In the case at bar, originally relief in the forms of motion for recusal have been filed and denied 3 times. Likewise, Glanville has denied the movement respective request for a certificate of immediate review. So when they filed that filed that recusal, it was denied. And then the judge didn't give him a certificate of immediate review because then he could have appealed it immediately, but he wouldn't give it to him. So they went above this judge's head to go ahead and get this done. Okay, let's continue here and see what else is saying. Chief Judge has obstructed defense counsel's attempt to have a disinterested party review the numerous allegations contained in at least 4 affidavits for misconduct and unfair proceedings. Okay, let's go down. I'm getting to the good parts, you guys. And then, okay, we mentioned that assuming this court would get the opportunity to review the decisions on the multiple motions to recuse unless or until the underlying case was concluded. So they're saying that the judge wanted to go through the whole case before he would even give them a chance to appeal. Glanville continues to hide behind purported standard that his actions will be reviewed in hindsight for abuse of discretion. Glanville's obstruction of defendants' rights to a fair and impartial trial has risen to a level that defense counsel now believes all attempts to obtain relief in the Superior Court of Fulton County will be ineffective. 3 motions for recusal have been filed and denied. And it says 2 writs of mandamus are already attached to the instant case, which were filed and pending for more than about 1 year. Therefore, any effort, let's go down and see what's going on, to file a writ of mandamus in Fulton County that will be heard by Chief Judge Glanville would result in frustration and lack of action. And Glanville's court is where writs go to die. So basically they're saying they give it to him and it goes on his desk and nothing ever happens of it. Okay, let's get down to the business. A secret ex parte proceeding was held on June the 10th, 2024. In attendance were Glanville, sworn witness Kenneth Copeland, which is Woody, prosecutor Love, and Hilton, investigators for the Fulton County DA's office, and members of the Fulton County Sheriff's Office, as a result of the proceedings on June the 12th, 2024. Okay, now petitioner requested that the preceding judge, Glanville, recuse himself from petitioner's trial for, among other counts, count 2, murder. Okay. Despite proceedings, all requirements of Uniform Superior Court Rule 25, the motion for recusal was summarily denied without following the required procedures. So they're saying he did not follow it, the procedures of that recusal. Glanville denied a request for a certificate of immediate review. A formal order denying the motion was entered on June the 14th, 2 days after the motion for recusal was filed. As Chief Judge of the Fulton County Superior Court, Glanville holds a unique position within the county which carries a significant amount of weight and power among his fellow county judges. Glanville has repeatedly refused to issue a certificate of immediate review that will permit the Georgia Court of Appeals to review his decision on the recusal motion, therefore invoking the original jurisdiction of the court to issue writs to petitioners only recourse. If not considered by this honorable court, the still incarcerated defendants will be forced to wait for at least another year or more of trial before seeking review. Okay, and the case at bar will be extremely lengthy with more than a year worth of transcripts to review. Emergency relief is requested because the witness that was preserved by Glanville is presently on the witness stand. That's little Woody. Absent emergency relief from this court in some form, Glanville will control the scope and substance of undersigned counsel's cross-examination of Copeland. So they're thinking that the judge would not let the defense, bring in the things they want to bring in to go after Woody. Okay, let's go down. Anticipated areas of cross-examination include Brady materials that counsel believes was disclosed at the proceeding but not provided to counsel as required by law, as well as joint efforts of the bench and state. Given the conduct during the ex parte proceeding, at least an appearance of impropriety, if not actual impropriety, cast as Paul over any ruling that Glanville may make during counsel cross-examination of Copeland. And I think what they're going to try to do is ask Woody, did the judge threaten you in that ex parte meeting? You know little Woody going to tell it. He tell everything else. Okay, let's see what else it says here. I just don't want to be repetitive, so I'm sort of glancing at it before we start reading it. Okay, that's repetitive there. Okay, issue presented. Whether Glanville was correct in failing to follow the mandates by refusing to refer the motion for recusal to an unbiased judge for hearing following arguments on June the 12th, particularly after making findings in an order of June the 14th that the motion was timely. The attached affidavit was legally sufficient and that the affidavit contains assertions of facts to support the allegations of bias. Okay, statement of fact. Okay, that's just talking about when the case originally started. Okay, let's get into this. The secret ex parte proceedings. A central figure, perhaps the central figure in the state case against Kendrick and the other defendants, Mr. Kenneth Copeland, on June the 7th, Copeland was sworn in. After being given a grant of immunity and being warned by Glanville that the incarceration may be the result of refusing to testify, Copeland continued to plead the fifth. Copeland was held in contempt and ordered incarceration by Glanville on that date. Glanville instructed Copeland and all parties that Copeland will be returned to court on Monday, June the 10th at 8:30 a.m., where Copeland would announce whether he was prepared to testify. Unknown to any member of defense counsel, an ex parte proceeding was held in Glanville's chamber on June the 10th. Among the attendees was Glanville, ADA Love, ADA Hilton, investigators of the Fulton County District Attorney's Office, deputies, sworn witness Copeland, and Copeland's attorney, Ms. Kayla Bumpus. No members of defense counsel was present at the ex parte proceeding, despite Copeland's invocation of his Fifth Amendment rights being at a critical phase of the trial. Neither Glanville nor any member of court staff nor the Fulton County DA's office made any member of defense counsel aware of the ex parte proceeding, either before, during, or after the proceedings. One or more members of defense counsel were later made aware of the ex parte proceeding with sworn witness Copeland, though not from Glanville nor from the DA's office. Specifically, Weinstein learned that Brady material was disclosed in the ex parte proceeding and withheld from all defense counsel. Okay, let me move it down a little bit so I can continue. Upon information and belief, the following events occurred at the ex parte proceeding with sworn witness Copeland in the chambers of Glanville. Upon information and belief, Copeland announced that he would invoke his Fifth Amendment right and not testify. Upon information and belief, Copeland stated that he would rather sit in jail for 2 years than testify. Okay, let's move it down a little bit. Upon information and belief, Glanville informed Copeland that Glanville could keep sworn witness Copeland incarcerated until additional defendants were tried, not just the 6 defendants currently on trial. Upon information and belief, ADA Love or Hilton informed Copeland that there were over a dozen defendants left to try. Upon information and belief, following the above perceived action by Glanville, working in concert with the one or more attorneys for the Fulton County DA's office, sworn witness Copeland stated at the ex parte proceedings that he would testify. So basically, they threatened him. Yeah, so upon information and belief, Glanville also presented sworn witness Copeland with a printout of the perjury statute and the false statement statute of the state of Georgia during the ex parte proceedings. Upon information and belief, sworn witness Copeland stated to ADA Hilton that if called to testify, he would simply lie on the stand. Important Brady material that has yet to be provided to Kendrick. Upon information and belief, in response to Copeland's statement that he would lie, ADA Hilton stated that she would not prosecute sworn witness Copeland if he were to lie on the stand. Important Brady material that has yet to be provided to Kendrick. Upon information and belief, sworn witness Copeland also stated to ADA Hilton that he would testify that he killed Donovan Thompson Jr. Important Brady material that has yet to be provided to Kendrick. Upon information and belief in response to sworn witness Copeland stating to ADA Hilton that he would testify that he killed Mr. Thompson Jr., ADA Hilton told Copeland that she would prosecute him for perjury if he testified that he killed Thompson. Important Brady material that has yet to be provided to Kendrick. These troubling facts not only implicate Glanville in an impermissible effort to join forces with the state to coerce Copeland to testify, but also demonstrates effort to repress Brady materials that should be provided to Kendrick. Okay, let's keep going. Attorney Kaylee Bumpus, by and through her counsel, filed a motion to quash order to show cause and motion to recuse, and then they show the exhibit on Friday, June the 14th, which supports the Weinstein affidavit. At a participant in the ex parte proceedings, Bumpus' first-hand account of this misconduct is credible. The fact Attorney Bumpus asserts are as follows. On Monday, June the 10th, at approximately 8:30, Mr. Copeland and his lawyer, Attorney Kaylee Bumpus, were escorted to the court chambers and conducted an ex parte proceeding regarding whether Mr. Copeland would testify. Those present for the portion of this ex parte proceeding was Glanville, Copeland, Attorney Bumpus, Lawyer Love and Hilton, members of the court security staff, and deputies and 2 investigators from Fulton County District Attorney Office and the court reporter. In chambers, Glanville asked Copeland whether he was prepared to testify. Copeland announced that he planned to reassert his Fifth Amendment privilege. A conversation among the parties ensued regarding Copeland's understanding of immunity. How Copeland thought he may testify if he did not invoke the Fifth and certain facts of the case. Okay, let's keep it going, y'all. Once Copeland learned that he would be held indefinitely by Glanville if he refused to testify, not just 2 years as he initially believed, Copeland yielded. Copeland's caution that his testimony would be a lie. Okay, so it says here, events in court about the time of the secret ex parte meeting. Okay, on Monday, June the 10th, all defense counsel were present in the Fulton County Courthouse at around 8:30 a.m., admitted entrance into courtroom, and seated within by 9 a.m. Defense counsel waited and waited. Between 11 a.m. and 11:30 a.m., Glanville took the bench and announced that Copeland was prepared to testify. Sensing something amiss, Attorney Brian Steele, on behalf of all defense counsel, specifically asked Glanville about the reason for delay. providing Glanville an opportunity to reveal that an ex parte proceeding had occurred and the content of the proceeding. Failing to provide any substantive response, Glanville obstructed Steele's attempt to discover a reason for the delay. That afternoon, when Steele's understanding of the morning events were presented to the court by Steele, Glanville shifted focus away from the extraordinary allegations to the source of Steele's knowledge of the misconduct. When Steele refused to divulge this information, City Ruling 1.6 of the Rules of Professional Conduct, Glanville held Steele in criminal contempt and sentenced him to 20 days of incarceration. Okay, what is this? Okay, it's just saying he's presenting this motion to recuse. Let's see. Oh, okay. Let's read this. On June the 12th, Kendrick filed and presented to the court his motion to recuse. During the 10-minute hearing on the motion, Glanville mischaracterized the motion as a complaint regarding his previous rulings. Glanville ignored the subject matter of the motion and affidavit, which was an accusation that the June 10th secret ex parte proceeding was in violation of at least Section 2.9 of the Georgia Code, which assures every person, including defendants such as Kendrick, a fair hearing. So it's giving the codes that they basically broke. Then it says, in the revised Georgia Code of Judicial Conduct, that says generally that judges shall disqualify themselves in any proceeding in which their impartial might reasonably be questioned. During June the 12th hearing on motion to recuse, Glanville refused to conduct the timely analysis required. Despite Weinstein bringing this to the court attention, Glanville refused to make any findings and denied the motion. Weinstein requested at that time a certificate of immediate review. That request was denied, foreclosing an opportunity to appeal Glanville's ruling. Glanville stated an appeal court could look at his denial at the conclusion of the trial. He wants to sit on this trial to the end. He don't care what it takes. Okay. So basically they're just saying he denied everything that I said every day, but yeah, it looks like it is every day. Okay. Let's see what this is. Okay, let's go down here. To compel removal of a judge, a petitioner from mandamus must show that a sufficient motion to recuse has been filed and that the motion has not been denied after assignment to a separate judge. To preclude mandamus, the alternative legal remedy must be equally convenient, complete, and beneficial to the petitioner. Okay, let's see what else is here. Glanville has failed to follow the rules in recusal and has violated multiple rules of the Georgia Code of Judicial Conduct. When a trial judge is presented with a recusal motion and an accompanying affidavit, the judge must temporarily cease to act on the merits and determine immediately whether the motion is timely, whether the affidavit is legally sufficient, and whether the affidavit set forth facts that, if proved, will warrant the assignment judge recusal for the case. And then they state some cases about this. Okay, this is Glanville failed to follow USCR 25.3 during the hearing of the motion to recuse on June the 12th. So okay, that's repetitive, you guys. So let's keep going. Same thing said there. Okay, and it's just saying he broke multiple rules and is bringing that ex parte. Okay. And let's see. Okay. Let's see. Capes. Petitioner requests this court direct Glanville to follow the law. Based on Glanville's own findings, Glanville should be directed by this court to assign the motion for recusal to an unbiased judge for hearing on the merits. They just want him to do his darn job and stop being a bully. Petitioner is further requesting a writ ordering Glanville to immediately produce an unredacted transcript to defendants of the secret ex parte proceeding. Petitioners further request that proceedings in the trial, it has a trial number, be stayed pending resolution of the motion for recusal. Petitioner also requests this court enter any further writs or orders as deemed appropriate given Glanville's action. They just want this done. And they got all the lawyers' information. Okay. Okay, that's repetitive stuff. And these are like the exhibits in this showing, the things that went down, what they talking about. And it's like their evidence of the case. It's 5 lawyers on this. Okay, certificate of service. Same thing. That was part of exhibit. Yeah, these are all just the exhibits, you guys. I just want you to see that that's what it is. It's just the evidence to support what they're asking for, which we went over already. Okay, and this is just yeah, so I'm sure, because I noticed yesterday I was watching the trial, right? And the judge was being extra, like, he was low-key. His demeanor showed he knew this. Because he was not as, like, strong-willed as he normally is. He was starting to be fair. Yeah. So it's too late for that now. So yeah, this is all this is just back up for their claims. So yeah, you guys, so we're gonna see what the Supreme Court, now this is the higher court. This is above the judge court. So let's see what they're gonna do, you guys. And we're gonna go from there. Thank you for tuning in. I appreciate all of you guys. Thank you.